Present here today. I am Shagnik Shen from BT second year and we would be your host for today. Ministry of Education MOE Government of India is making every possible effort to drive innovation and entrepreneurship to emerge as one of the focal points of our education system. Thus, the MOE Government of India has established Institutions Innovation Cell IIC to systematically foster the culture of innovation amongst all higher education institutions, and IPRs, intellectual property rights, is also an important part of it, which gives the rights to the persons over the creations of their minds so that the young minds can not only transform their ideas and innovations into reality but also legal issues regarding privacy and patent filing. So taking part in this initiative, Institutions Innovation Council of Bengal Institute of Technology, that is IICBIT 5.0, presents the workshop on intellectual property right, IPRs and IP management for startup. Thereby, I would like to take this opportunity to welcome you all to this wonderful session where our guest speaker of the day, Dr. Jyoti Sekhar Banerjee, BTech, ME, PhD, PG Diploma in IPR and TBM, FIITE, former Post-Doctoral Fellow at Nottingham, Trent University, UK, Head Department of CSE AI and ML, Professor in Charge R&D and Consultancy Cell, BIT, Nodal Officer, IPR Cell, BIT, Bengal Institute of Technology, Secretary-Computer Society of India, Kolkata, Secretary-cum-Treasurer, ISTE, West Bengal Section, ExeComm member, IETE, Kolkata Center. So before we start the seminar, I would like to call the President of IICBIT, Arpita Chakrabarti ma'am, and please give a big round of applause for her. President of IICBIT. The Vice President of IICBIT, Dr. Tapan Kumar Pal sir. A big round of applause, sir. The convener of IICBIT, Professor Debolina Barik, ma'am. And for our speaker for today, Dr. Jyoti Sekhar Banerjee, sir, to be kindly seated. Now I would request the President of IICBIT. Now I would request the President of IICBIT 5.0, Dr. Arpita Chakrabarti ma'am, to say something.
Very good afternoon, my dear students. How are you after tech phase, cultural phase and all? How are you?
Good.
Fine. So back to the college again now after all these extravaganza. So you have to start the new session from today only you have started, right? Or from yesterday, whatever. But from this very beginning, you have to think in a new note also. Because the new semester is going to start, and in the last time we have observed the tech phase, many of you have participated and won exciting prizes also. How many of you received the prizes? Raise your hands, please. Congratulations to all who have received the prizes and those who have participated. We have seen that we have arranged product fair, back-to-back events were there, right? Product fair, then after that it was IPRs conducted some competition, and then Dept, of course, with lots of events. So what we have found that you have made interesting projects, many of you, and it may be biotech related, it may be hardware, it may be software, it may be mixed type of projects, and for that you have received exciting prizes. But at the same time, we have seen few projects which were repetitive. During the time of judgment, you have seen, you have got the feedback from the judges that the projects are good, but what are the applications? Many of you haven't thought of the application. So application parts were missing. And some judges even asked, is the project patentable? How many of you got this feedback from the judges? Is the project patentable? What is the unique feature of your project? Everybody had faced the same question. What is the USP? What is the uniqueness of your project? Had it now? Yes? So you have to see, making a project doesn't mean you'll be searching some project in the YouTube and just purchase the things from the chutney or from the online sites and make it. It's not only the thing. I find many of you have started discussing right now how to make the new projects. Is it so? Many of you have started planning for the new projects, I find. Is it so? Oh, that's very nice. We are going to organize some other competitions for you then. But for the time being, please have patience and listen to me. That while making the projects, few things are to be kept in mind. Only making a project is not everything. And presenting it to the judges, and after the event, after demonstrating your project, many of you actually informed me, many of you became sad that ma'am, it was not went well, something like that. But don't be sad for that. Before making the project, think over it. What are the applications? What are the unique features? I mentioned it earlier also, that you may find some project from YouTube, but add something of your own innovative thing. And then only you can claim the project as your own. You can file the patents. The government is continuously asking us to file the patents. So today and earlier also we have conducted seminars what is the utility of IPR, knowing of IPR, how to file the patents and all. And today also you'll be coming to know the things from sir, our very own faculty. And throughout the year, it is not that during the tech phase or during any competition you will be making projects. Somebody said, okay ma'am, this time we made this mistake, next year we will be doing that. No, don't sit and wait for next year's event. The event is over. No, it's not over. It's a continuous process. Because throughout the year we find invitations from different hackathons and competitions organized by different colleges. And as accordingly we ask our students to take part in those events. And in many institutions, you know already, our students have won prestigious awards. Right? So you have to be also be the part in that tradition. And following that, throughout the year, it's my suggestion, along with your course curriculum, please take time, please find out time to make the projects. And not only the repetitive projects, try to find something innovative in your project also. Then you can shine better. Okay, that's it for today. Thank you.
Thank you very much, ma'am, for your words of wisdom. Now I would like to call the Vice President of IICT IIT 5.0, Dr. Tapan Kumar Pal sir, to say a few words.
Good afternoon, all of you. In the dais, the distinguished our speakers, today's speaker, and all my colleagues of BIT and students. Now today, we are focusing on IPR. I think previous 15 or 20 years, 20 days back, you can think about different type of project. There's a competitions and there are a lot of models you are showing that. But But this kind of work is very good for your enjoyment and the new things. But one thing is very important. If you create anything, you should have mind that it is your creations. But if your curations can be still to others, but how can prevent it? So this prevention method is the IPR. The solution is within the IPR. So if you create any new things which is unique from the others, so you can file the IPR, you protect your idea, and you have also gives the honor for the inventor of these things. This kind of things only added your future, because you know that any kind of patent or design or process gives extra advantage for your career. So I think not only you can look at different type of project you are presenting or creating different type of device idea, but I think equally it is very important to look at the IPR possibility of your inventions, so that you can add your career extra kind of things that can give you better futures. So today, our own faculty, Dr. Jyoti Banerjee sir, this is also a very well-known person for known the IPR and other things. So he gives deliver of different type of IPR system and how this kind of IPR system can help you to protect your creations and design and different type of work activity. So let's go about the seminar for that workshop. Thank you.
Thank you very much, sir, for your words of wisdom. Now I would next like to call the convener of IIC BIT 5.0, Professor Deborina Barik ma'am, to say a few words.
Good afternoon, everybody. On behalf of IIC BIT, I welcome Dr. Jyoti Sekhar Banerjee, Professor and HOD of CAC AIML Department. Heartily, I welcome him for this session. He has taken special training on IPR also. He has different certifications on IPR. So we have heard about many property rights. We have not heard about IPR, intellectual property right. Intellectual property right is something that is for your own creation. You get a legal right, so that you can claim it. It's a legal right, and it is for a specific duration of time. We have heard about ownership property, we have heard about equality property, legal laws, everything. But IPR, the first IPR was developed in 1956. It was a copyright act, and that was the first IPR act that was developed. And Professor Jyoti Sekhar Banerjee will tell you more about these things in today's session. So I hope you will enjoy this session, and heartily I welcome all the participants and teachers too. Thank you all.
Thank you very much, ma'am, for your words of wisdom. Now I would request my co-host Aditya to introduce our guest speaker.
Today our guest speaker is, as you all know, Dr. Jyoti Sekhar Banerjee sir. He is currently serving as the head of department in the Computer Science and Engineering AI and ML department at the Bengal Institute of Technology, Kolkata. Additionally, he is also the professor in charge R&D and Consultancy Cell and Nodal Officer of the IPR Cell of BIT. Dr. Banerjee did his post-doctoral fellowship at Nottingham, Trent University, UK, in the Department of Computer Science. He also completed the postgraduate diploma in IPR and TBM from Macau, West Bengal. He has teaching and research experience spanning 18 years and completed one IEI funded project. He is a member of CSI, IEEE, ISTE, IEI, ISOC, and fellow of IETE. He is the present honorary secretary-cum-treasurer of the ISTE West Bengal section. He is the current honorary secretary of the Computer Science Society of India, Kolkata chapter. He is also the executive committee member of the IETE Kolkata Center. He has published over 6 papers in various international journals, conference proceedings, and book chapters. He is the editor-in-chief of American Journal of Advanced Computing, AJAC, Smart Society, USA. He is the leader author of a textbook on mastering digital electronics, principal device and application, and co-editor of the 7 books. He has also co-authored another 2 books and is currently processing 4 edited books in the reputed international publishers like Springer, CRC, Press, DeGruyter, etc. Presently, he is also processing 4 more textbooks. Those are now in press. Currently, he is serving as the General Chair of ICHSC 2022-2023, General Co-Chair of GCAIA 2021. Dr. Banerjee is the Program Chair of the Human 2023, GCAAIDS 2023. Dr. Banerjee is served as a guest editor of ICAUC ES 2021 and ICPAS 2021 issue in IOP Journal of Earth and Environmental Science, Physics, Scopus Index Proceeding. His area of research interests include computational intelligence, cognitive radio, sensor network, AI/ML, network security, different computing techniques, IoT, WBN, and export system. So without any delay, let's welcome with a huge round of applause Dr. Jyoti Sekhar Banerjee sir. Now I would like other teachers to take their seat.
Hello. Okay. A very good afternoon to all of you. Especially, I would like to thank IIC BIT for inviting me for this session. Here I can see a few HOD, faculty member of BIT, and my dear students. Before to start the session, that is not the 6th paper, it is 60, right now it is more than 70 paper I have already published. Again, few things the president of IIC BIT, vice president, convener, they have raised few issues. Those are very alarming. And I would like to address those things during my session also. First one,
repetitive project. It is a common problem for all college university. So definitely the question arises in your mind, how to cross this bar. Am I right? Number one. Number two thing, you know, whenever you are going to design, whenever you are going to develop anything, each and every year, our student, they are developing lot of projects. But the thing is that these projects, if they are not properly filed in any format means either you can file it as a patent, you can file it as a copyright. Which particular project goes to copyright section, which particular project goes to patent filing or something else. I'm intentionally mentioning this particular fact that lot of ways are there. So being a student of engineering student, obviously, it is a very interesting fact that how to overcome and how to get things done easily, because if you have filed a patent, if you grant this, if you receive grant of this patent or copyright or anything, it will certainly reflect in your CV. So what is the point? First point. The first point is that what is the motivation? Why you are going for patenting? Why you are going for copyright? The first issue, that is, it will enrich your CV. Number one. Number two thing, another speaker, another someone, they raised another point, that is repetitive project one part. Another part is that it is a legal thing. Please minutely listen. Patent, copyright, or any type of intellectual property right. So it is a legal part. So whenever it is a legal part, it is related to some extent court or some attorney is attached with this particular process, right? So you need to know that whenever it is a part of a or case of a legal things, so you need to aware few things. You are doing something knowingly or unknowingly. If you are doing some not a legal way, if you are not filed, it may be penalized for you. So this lecture is very, very important. Two parts are associated with this IPR. One part, that is the legal part. Legal part means clause number, section number, 2 point something, I am not going to disclose. This is the part of the legal person or patent attorney. What is our role? With a technologist. In my lecture, I would like to focus on only technological aspect, which is very relevant to all of you. Is it clear to all of you? Okay. So you know that already. Please be seated, please. So already you know that whenever you are designing something or developing something, at that time, some people or we are telling that, okay, do some patenting. So what is patent? Patent is an exclusive right. I am not going to discuss what type of right. Obviously, going to discuss soon. A patent is an exclusive right granted for an invention. What is the nature? It may be a product or it may be a process. A product can be patented and process can be patented. Okay? That provides a new way of doing something. What is the meaning of this? That means somehow any solution may exist. If you want to revise or if you want to construct in other way, it is also equally patentable. Is it clear, this point? If any point, if you are not able to interpret, please kindly let me know. Okay. So provides a new way of doing something or that offers a new technical solution for a particular problem. So all we know that we are basically surrounded by lots of problems. And some of the problems are being addressed by someone, some existing solutions are there, right? So solution, I'm just addressing the particular point, that repetitive project. So whatever maybe project you are developing, definitely someone has invented or doing some solution. So this is not the problem. Problem is that you try to revise, you try to incorporate some new feature into the existing one. That could be applicable. Is it clear? So how you can overcome? And again you can ask me that, sir, you are telling me that try to revise, try to add some point. Sir, you are not telling us which point we are going to add and how can we know that there is a process. Soon I am going to disclose that also. Okay. Which part you need to revise? Which part you need to work on further? Okay. Please go to the next. So few salient points you need to know. Okay. The first point, the statutory definition of invention is new product process having inventive step. Point to be noted, inventive step. And capable of industrial application. You are developing something which do not have any industrial application. Whenever you are going to apply for patent, it will be directly rejected. Is it clear? Industrial application should be there. Inventive step, the steps should be inventive one. Okay? It should not be a natural process. Natural process are not at the purview of patenting. Okay? That should be an inventive process. A new invention means any invention on technology which has not been anticipated by publication in any document. Any document means any document. If it is published in newspaper that is also considered a publication. Not only journal or any blog, anything. Any type of publication at that time will be considered as a publication. Okay, it is a unique, it should be a unique one. This point is very important. By publication in any document or used in the country or elsewhere in the world, another point that should be a global point. Suppose you are developing a product which is a new one for our country, but it is already available in UK or USA. Is it a patentable? No. So, before the date of filing, that means when you are going to file your product, patent application with a complete specification, that is subject matter, has not fallen in the public domain, that your topic should not be in the public domain. The invention should not known to everyone. Okay? The next point, the nature of right, very important point. The nature of right obtained from the patent, it is basically a negative right. It is basically, whenever we are dealing as intellectual property right. So what is patent? Patent is a negative right. Negative right means this particular process is applicable for preventing your invention. Why you are going to file your patent? That means whatever may be the things you are developing or developed, you need to be protect that particular product from others so that others cannot claim that this is my product. So that is why this is a negative right to prevent from the others. The term of patent, that is another important thing. Whenever you are going to apply for a patent, if your patent will be granted duly, the tenure will be 20 years. After that, you need to apply again for renewal. Okay. So one thing is that you know that all you are the student, you are not at all a patent attorney. So the another problem, why less number of patenting happening in our country or any institution, university like, okay. The thing is that as you are the student, you don't know how to file patent, right? All you are engaging yourself for developing some new product, but you don't know how to file patent. For your ready reference, I can tell you that inventor can directly file a patent. Assignee of inventor, suppose you are assignee, sir, please on behalf of us, file the patent. Okay. Legal representative means patent attorney are there. Or assignee of legal representative. Suppose legal representative at the same time assign some person. Okay. So it is clear to you all that whenever you are developing a product, it is not necessary that you need to file a patent. Okay. Next. Patent application should be filed before any publication. One very important point that has to be noted very clearly. If you publish in any journal, one question may arise in your mind. That particular product or that particular invention can be patented? No. Any form of publication, book publication, book chapter publication, journal publication, conference publication, once if you are published, it is under the public domain, known to everyone, right? So it is not patentable. The benefit of filing provisional specification, one important point, whenever you are filing your invention, suppose in last week, suppose 4 or 5 your friends planned something, design a product, planning, but it is not completed. You are planning that, okay, we want to develop such type of product, that particular product will be address this particular problem, okay. But all the thing you have not implemented. Another important question arising in your mind, is it a patentable? What do you think? Yes, there is option. Option means that is two types of specifications are there. One is complete specification, another one is provisional specification. Okay. After filing provisional specification, within 12 months, you need to file the complete specification. If you ask me, sir, please tell us in one line, what is the difference between provisional specification with complete specification? Just one line difference. Claims are there. In any invention, you are claiming that my product provides blah blah, my product having this feature, right? Claims may be absent in your provisional specification, but it has to be included within the complete specification. This is a single line difference between provisional specification with, suppose I am thinking that, okay, I am developing some product and another competitor company, they are also doing the same product, and I am a bit of worried that, okay, before patenting my product, the competitor company immediately filed. So what I need to do? Immediately I need to file the provisional specification. It may not cover all the features, but ideas. But once I told you that ideas are not patentable, but whatever may be the concept, whatever may be the things you have considering that you are going to develop, you can be filed. That is known as provisional specification. What do you think? Is it a good one or not? Okay. The meaning of novelty, another important point. Novelty under the Act is global novelty. I told you that the product may be absent in India, but may be available in other. The concept should be global, globally novel. The definition of inventive state, I told you that inventive state is a very important point. Is a feature of an invention that involves technical advances, economic significance. That means what is the meaning of inventive state? That may be, provide some sort of, improvement in steps. Suppose you are going to develop or something product in biological product, some chemical product. Suppose prior to your invention, 5 or 6 steps are required. Suppose, but you are developing the equal product within 3 steps. The final result will be the same, but your process is a novel process. I already told you, patent can be happen for product or process. I told you initially. Okay. So involves technical advance and economic significance. Suppose you are developing in such a way which is less, require less financial support, less money. That is also novelty, right? So inventive steps is another important point. Capable of industrial application. I already covered this particular point. A product cannot be patented unless it has any industrial application. It should have some industrial application. Okay, otherwise it is not under the purview of patenting. Next. New invention. I already told you another important point. New invention. New invention is a one line has not been anticipated by any type of publication. Any type of publication, under any type of publication. New invention means any invention or technology which has not been anticipated by publication in any document. Okay. The subject matter has not fallen in public domain. This is the most important point. Suppose, all you are the young guys, you are developing a product, you are motivating, and this particular fact is shared within some public media, in some blog or else. Whenever you are going to file your patent, at that time you are getting that you are giving some negative report. What is the negative report? It is already reported in public domain. So whenever you are developing something, do not even post in any public media. Is it clear to all of you? Why I am repeatedly saying this? Not only in publication, journal, conference publication. Suppose you are in a blog, concept is released. You just can't estimate. Suppose in any hackathon, in any whenever state government or central government or ICT, instruct us to upload your project in YouTube. You can't imagine how many number of startups they are basically seeing your project. Basically, the ideas comes from your green mind. That is the most USP for several startups. Okay. So whenever you are publishing these ideas are not being patented. Okay. Next. What can destroy novelty? I already told you. Prior publication, prior claiming, prior public use, prior public knowledge. So all these should not be considered your patenting. Okay. Next. These stages are very important. If you can consider, suppose we are developing some software, we can say that a software landscape. That means from the requirement analysis to the product will be installed in a client side. So we can consider this is a software life cycle, right? Or software landscaping. So this is the patent landscaping. Filing of an application, or it may be a provisional, it may be a complete. Suppose you have, after completing your invention, you are going to file for patenting. Okay, so it has the complete specification, or initially after getting the idea, I'm going to file it for provisional specification. So this is the stage number 1, filing of application. You know, if provisional specification is filed, complete specification to be filed within 12 months. Within 12 months, you need to file the provisional complete specification. Otherwise, your provisional specification will not be considered. So, after the 18 months, promptly after 18 months from the date of filing, it will be published in a patent journal. Okay. After publication, it will be within 48 months from the date of the filing. You need to request for the patent office to examine your product. Okay. One report will be raised, that is FER, Fast Examination Report. And that particular report and that particular examination process will be conducted by the third party representative. Okay, they will review your product, whatever may be the questions, whatever may be their technically, whatever may be the steps. They need, suppose they can suggest something, they can ask few questions, so you need to answer all of these questions. You need to address all of these questions. That is the first examination report. Okay. So, after addressing all the queries, okay, after you need to submit all the queries with response to the patent office. Okay. If your response, one interview at that time will be conducted. At that interview, if you successfully answer all of the questions, so your patent will be granted. Suppose one of your invention, suppose will be granted. So what you can do? You can make it or sell this product to some company. They can develop a product. That particular process is known as technology business management. All the other technologies, listen very carefully, because the theme of this lecture, that is IP management for startup. Suppose you are going to purchase any product from any company or any shop. What are the product? Suppose for a tea stall, tea is the product for that particular stall. Suppose all you are the technologist. So it is highly expected that whenever you are going to, open any startup, at that time your product should be a technical product, right? So you are providing some solution. That particular solution will be considered as a product. And that particular product, suppose you have developed any product and you have filed this product. So after filing or after receiving the grant, you can open your startup or you can sell your product, because licensing are there. Licensing means, suppose you are considering that, okay, I will remain a technologist. I am not going to involve myself for selling this particular product from my end. So you can provide licensing to others, some other company. Some other company, they can sell your product. In this way, this particular process is covering, right? So either you can sell it directly comprising a company, or you can give some license to other party, third party. Okay. One thing is that if some company at that time, whenever you have received grant of a patent, some person or some company may raise objection against you. Objection means, suppose I am claiming, no, I have already invented this product, I have and produced some legal documents. Okay, there is some forms are there. Within, all objection to be compiled within 12 months. Any person can file objection against any granted patent, and that particular objection will be considered, and decision will be taken by the controller whether the objection are legally correct or not. Okay, so this is the entire scenario. This is the entire landscape. So once it is granted, it is not considered that no one can object, may object. Okay, so even suppose just 1 or 2 years back, COVID-19, this is a huge pandemic. All we have suffered from this COVID-19, right? But most important thing is that the detection kit or several types of things that are related to the COVID-19, which was duly patented at least 10 to 15 years back in 2010. Okay, so the thing is that no one can say, whatever whatever may be the product you are developing may not be useful for this time. No one can say that after 5 to 6 years, your product, if you are duly filed this particular product for patenting, right? So it may be useful for that case. Okay, so I'm giving just this example. Go to the next slide. Steps for patentability assessment. This is another very important point. Criteria for filing patent application. I already mentioned that novelty should be there, inventive steps should be there, inventiveness or non-obvious. Suppose, I'm giving you an example. Suppose, suppose you have developed a water meter. Okay? So if I ask you how to develop, okay, all you can tell me, sir, you may use some, Arduino, Raspberry Pi, you can use some sensor, you can develop some mobile application. Am I right? All the things, whatever you have developed, you have mentioned in your document. That means patent application, right? Okay. Some other competitor company, what you are doing, it is after publication, all we can see the competitor company, within a minute, they saw all the documents and immediately, using some reverse engineering, develop the same product. Am I right? Got my point? Whatever may be the product you have developed, you have written all the things in a detail. Based on the lecture sir told us, okay, so we need to write each and everything. Okay, so other competitive company immediately seeing all the document, develop the same product, and your product is not going to be sold anymore. Obvious, your write-up should be not obvious. That means, instead, suppose you have used Arduino, you have used Raspberry Pi, you are not going to write Raspberry Pi Arduino directly. I'm just giving you an example. Okay, you may write instead of Arduino a microcontroller. We have used a microcontroller in our problem. Is it clear to you? So something you need to hide from the others. It should not be obvious to the other. Your write-up should be written in such a way so that people directly cannot interpret, and using some reverse engineering, it is not possible to construct the same product. So what are the steps are related? Steps for patentability assessment, whenever idea comes to your mind, a particular idea, okay, any idea. Suppose I am just give you an example, take a water meter. Suppose you are thinking that, okay, so right now water scarcity is there, so we can develop a product. So this is an idea, right? So what you need to do after getting this idea? Anyone can tell me? Suppose anyone, or you can take any project. Whenever an idea comes to your mind, what you need to do? Anyone can tell me what you need to do? What should be the next step? Any idea comes in your mind, we need to develop this. What do you need to do? Any idea? This is the answer. This is the answer for the to prevent from the repetitive project. What do you need to do? Sorry? Google says, very good answer. Good answer. This particular technique is known as prior art, state of art literature review. Okay. Related studies. Several names are there. But the concept is remains same. That is, what is the existing research of this particular topic? Definitely some person are already developed something for water meter, suppose. So you need to know that. And if we can use this technique for our test project, any project, what you are doing, what you are developing, before to do the same thing, please do the literature review. Okay? Then you can see that what are the existing developments are there, and try to incorporate some new ideas with the existing one. That could be a novel. This is interesting. If you can incorporate one feature, that is also acceptable. Is it clear? So how to eliminate or how to solve this particular problem? Repetitive project is a big issue nowadays. So after ideas, a state of art review or such should be carried out. After that, assessment of ideas and technology. So definitely, whatever may be the existing technology, a group that is you or 4 or 5 member group, or you are reviewing, try to find out what is the existing technology. To some extent, you try to incorporate some new ideas and develop the product. Okay, and what you need to do after that, the assessment of ideas and technology. That some sort of ideas, some sort of technological advancement you need to incorporate with your project, right? That particular idea may be accepted, may not be accepted. That is different thing. But right now I am discussing in the step number 3, that is invention. If the idea rejected, why it may be rejected? If less amount of novelty found. Suppose what you have developed, this is a repetitive one. That is lack of novelty. Is it clear? If you are do not carry out literature review, you are going to produce the same product which do not have a novelty. So that is why idea will be rejected. If idea having some amount of novelty, it may be considered for patent drafting. Okay, this particular product having some amount of novelty, some amount of inventive steps, some amount of industrial application. These 3 points are very important. Right, I already told you. So we are considering that each step, if it is lacking novelty, it will be rejected. If the product do not have any inventive step, it will be rejected. If the product do not have industrial application, it might be rejected. We have considered that all of these features already available in your product. So this particular product may be patented and should be filed properly. So in this way, patent is filed. And after getting the FER, that is the first examination report, we are expecting that all you can satisfy all the queries which is raised in first examination report, right? So it is granted, and I already told you, after granting your product, it might be received some amount of objection from others. Okay? So you need to, if you receive any objection from others, you need to proceed technically that yes, this is the existing research, I have produced this particular product using this way. So if you are correct one, if you have carried out the literature review correctly, prior search correctly, so no one can claim. Okay, their claim can be null and void. Okay, next. So already this point, I already covered that in prior art, already he told us that Google search. Okay, so Google search may be a one particular platform. Google is a particular platform. Some other platforms are there. It may be considered within a handbook, textbook, journal, dissertation. Okay, any type of industrial or trade publication, newspaper, website, even technological blog may be considered within the prior art. Okay, next. When, that is a very important point. When you need to carry out this prior art or literature review, that is when it is just an idea. Okay, you have just last night considered, okay, we need to develop this particular product. Immediately in the next day, when you search in several platforms, you find that this product is already available. So this is not a novel one. So you need to revise, you need to try to incorporate some new ideas. Okay, and after, the criteria for getting a patent checked, whenever your product, suppose this particular idea comes in your mind yesterday. So 3 months, 4 months, 6 months, 1 year, you have taken to develop this particular product, right, Emma? And whenever, after the idea came in your mind, immediately you search the literature review or prior, you find that no such existing products are there. You have started to construct or to develop the product. But after 1 year, when you are going to file your patent, this patent getting some objection. Because whenever within this 1 year you are developing the product, some other company, they have already filed. So, first time literature review need to carry out, that is after the idea. Okay, and the second one, before to file the patent, you need to check whether any existing product are available or not. Is it clear? Any question? Okay, next. These documents are very important. Bibliographic information, technical document. These are the date of filing, publication, name, address of the application, title, classifier, abstract. These all the bibliographic information. We are rather interested in this part, that is in technical information, state of art, description, drawing, claim. These are the technical documents. All you need to design or write very carefully. So 2 sets of documents are here. Okay, one is bibliographic information, another one is technical information. So this particular part, state of art, description, drawing, claim, you need to write for your product. For your product, you need to write. So, invention again in two categories. One is statutory, one is non-statutory. Statutory means new product or process involving an inventive state and capable of industrial application. What I just told you, that is a statutory. What is non-statutory? Solution of a specific problem in the field of technology, product or process. Whenever you are going to revise anything, that existing solutions are there. So at that time, it may be a non-statutory. Okay, next. So I already covered this particular page. Next. This particular slide is very, very important. I already told you that two types of specification are there. One is complete specification, one is provisional specification. After getting the idea, if you want to file your product, so provisional specification should have these characteristics. Description of essential feature of invention. What are the features? Next, need not include claim. I already told you the difference between provisional specification with complete specification, that is the claim. Claim should be incorporated within the complete specification, and it may not be present in the provisional specification. Provisional protection from early stage invention. You want to protect your idea, that is the early stage of invention. You want to protect, so you need to go for. তোমার মধ্যে ভয় রয়েছে যে তোমার যে আইডিয়াটা, সেই আইডিয়াটা চুরি হয়ে যেতে পারে। Immediately, if you feel such type of thing, immediately you need to file the patent. After getting the idea, just one step is there, that is the literature review or prior art, okay? And whatever may be the thing you want to develop, you need to write down the features. What are the features in your product? You need to write down and file the provisional specification. You know, another important point, that is unity. A patent may have more number of inventions, 2, 3 or 4 number of inventions. Suppose in your product 2, 3 inventions are there, but you need to write in such a way so that it should be considered it is a one invention. Okay, this is the features of complete specification. Whatever may be the features available in provisional specification, all these features are also available in complete specification, apart from this one thing, that is claim. Okay, so claim has to be incorporated with the complete specification. So this is the format of provisional specification, just giving you the nominal information. These information you need to provide. So preamble, title, field of the invention, object of the invention, brief description of the invention. So for filing provisional specification, you need to give just this simple information. Okay, what should be the title? The most interesting thing, you know, within this very limited amount of time, or within one lecture, it is not possible to cover all of the aspects. I can give you a simple example. Suppose what should be the title of your invention? That is also very important. That you cannot provide the title of your invention beyond 20 words. It should have 15 to 20 words. Because I already told you, this is a right, and this particular right, you know, some legal aspects are there. Each and everything very much stipulated. Okay, so what should be the thing you need to write within the objective? What should be the things you need to incorporate within the title? That should be very much focused. Okay, please go to the next slide. Suppose the title of the invention. We are expecting that states the specific feature of the invention should be focused within the title, should be precise, short title, okay, and within the 50 to 20 words. Field of the invention. These 3 points again should be concise, field of application of the invention, and disclose the basic nature of the invention. So within this particular point, field of the invention, we are expecting this here. Next. Background of the invention. 3 points again there. Background means state of the art, advantage of the product, need for the invention. That means literature review. Whenever you are trying to find out whether any existing product are available or not, what is the utility to carry out this literature review? Anyone can tell me? What is the utility? Suppose you are conceptualize a particular product. Right now it is in the IPR, not at all implemented. Okay? So you have carried out prior act, that means literature review. I am asking you, what is the benefit of this? Please give me a one-line answer.
If someone copy, we have right to tell that they have pirated.
Very correct. In other words, in your sentence, I am just changing, that is the need for the invention. Suppose this particular invention already implemented. So we may find out need for the invention, whether the invention is actually needed or not. Suppose I am not able to find any literature review. Immediately, what should be the realization? This is the need. Nothing is available, right? So the need of the invention, that is the biggest motivation for our technologists, right? Next. Object of the invention, again, advantage of the invention and problem to be solved by the invention. That means what type of, each and every invention should be addressed any problem, right? Each and every invention. So the problems to be solved by the invention, that has to be under the purview of the object of the invention. Okay. These 3 things, very important point, each and every patent, you need to claim something. That my product having this, my product having this feature, right? These are the claims. So you need to claim that this particular product having this particular feature is not available in any similar product. Right? So 3 things are there: objectives, content, format. Go to the next slide. Within the, please skip this. Skip. Yes, this point is very important. You know, suppose in a particular patent, 10 claims are there. Anyone can tell me which claim having the highest priority? That is a first claim. You see that the principal claim, the first claim which defines the essential feature, the first claim of your product, perhaps telling everything. All the other claims are considered to be the auxiliary claim. Is it clear? But you, in your write-up, if you have not listened carefully to my lecture, you might be placed the most important feature, suppose in 4 or 5, your application will be directly rejected. Is it clear? So first claim should be the most important claim for your invention. And all other the auxiliary claim. Go to the next slide. How we can write down the claim. So these are the things that there. Should be a single sentences. All the claims should be written in a single sentence. These are the characteristics. Should not contain TM. TM means which a trademark. Anything you need not to write. Suppose Google, Microsoft. This particular term having the trademark, right? Trademark means in the right hand upper side TL. Okay. Each and every company having its own trademark, right? Should not be too wide. You have written each and every claim having so many lines. No, each and every claim should be a single line. Very much focused. Okay? Go to the next slide. So this is the, again, all you want to know. So we have we have listened a very lot. What should be the cost we need to bear for filing patent, right? So these are the some features, some points are there. What is the filing application of patent? So these are the points are required. Apart from this, some other fees are there. But apart from this list, I can suggest you a very wise point. Please listen very carefully. And this particular point I have not received from any books or any source, based on my experience. That is, whenever you are going to, develop any project group, please try to keep at least one woman. Okay. Actually, the thing is that there is an option for patenting. If one female inventor in your group, it is having at least 2.5 years. The time will less. That is 2.5 years. The normal process it will take 3 years. If any woman invented in your group, so it is just within 6 months. This is I am giving you this particular advice based on my experience. Okay. So the women empowerment nowadays is a big issue, and that is why the government has taken this decision. So please try to do this. And some of these are my published patent. And the most interesting fact is that all the inventor perhaps known to you because some of your seniors. Okay. Some of your seniors you may find out. Go to the next. Go to the next. And this is the last German patent. From this particular point, patent you need to file country-wise. Whenever you are going to publish a paper cannot be published nationally. That this particular paper is published for India, for Pakistan, for USA. No. But patent can be filed country-wise. You have developed a product. So for every country, you need to file a product. Suppose you want to make some business. Suppose in UK, US. So separately, you need to file that particular product in US, UK, Bangladesh, China, Japan, in each and every country. Okay. So it is not at all. There is no scope that in one place. Okay, you file your product, and this particular product is patented globally. Okay, so it is not at all possible. Okay, thank you. I will be highly delighted based on my lecture or the initiative taken by the Bengal Institute of Technology we have set up recently, IPR cell. Some of the invention from our institution will be duly copyrighted or duly patented. That will be the most important thing for us. I have not covered copyright in my lecture. In separate, if in other platform, one lecture may be possible for copyright. In India, Software or program algorithm cannot be patented. Listen very carefully. Algorithms, programs are not patented. To some extent, any type of hardware should be incorporated in your project. Otherwise, it will be not considered for patenting. It will be considered for only copyright file. Okay? So we may be discussed in a separate session. So if you have any question, please. Very good question. At first, AI is a technique. AI is a technique.
I just want to interrupt. Why are you laughing so much? Do you have any query? Please ask. If she has any query, please stand up.
Both of you,
Please put your query.
please. I'm highly delighted to answer. Please.
Please.
So why? Still, why? Why you are so laughing?
Every time when the delegates come, they give us this complaint. Students are creating noise and all. If you are not interested, please stay outside. I know you'll be receiving your order.
Do you know the answer of his query? Do you know? You can answer. Maybe it is known to you. Can you answer this question? The question is very interesting. As we know that this is the era of AI level. All we know. Please. No problem. Please, if you can answer. So please sit down. AIML, this is basically, it is a subject. A lot of things are there, lot of tools are there, lot of methods are there. Okay, so, you can use this method to make a system intelligent, to make a system more productive, to incorporate some novelty. We have discussed a lot regarding novelty. Suppose we have developed a product which is not at all AI enabled previously, and now you think about that you want to develop the same product and you are going to apply AI. Maybe we may receive some better outcome. That is the novelty. Applying AI, you may find a better result. Some less number of steps are there, right? So these may be the advantages. So you can incorporate this technique within the existing process. So he actually raised a very important thing, that how research we are carrying on. Actually, all we are not at all a Newton or Einstein. What we actually do, the thing is that a lot of existing solutions are there. Whenever a new tool or new technique comes, we try to apply within the existing one. And definitely, whenever the better tool can provide or can produce some better result, certainly. So whenever you are going to apply any AI tool or any AI technique in an existing product or existing system, certainly that product may produce some better result. That could be the enhancement. That could be produce some novelty. This is the important thing. And you can encourage to use this thing in your existing product. Okay? Any other question? So I do believe that it is a process, it is a culture we need to inculcate in our college, that it should be carried out. I do believe that IIC, BIT are continuously doing such type of initiative regularly, inviting guest speaker and discussing some novel ideas, some brainstorming sessions. I do believe that such type of IPR initiative will be continued in near future also, because the government of West Bengal and government of India, they are also very much eager to continue such type of process, and they are expecting more number of invention. You know, nowadays, Smart India hackathon in school level, Toycathon in a school level, auto tinkering lab in school level. You just can't imagine that so many invention. I am also involved in various school with the auto tinkering lab. I just can't believe that the project I have seen from the Chila school in Midnapur, the 7A standard student, they have developed so much advanced project. Even they are applying in AI also. Nowadays, in this from this year, AI is already incorporated with the existing 10 plus syllabus, right? So more number of challenges comes to us that we need to develop some more refined product. So please do not hesitate if you have any idea, if you want to file, because in your college, Government of West Bengal has set up a IPR cell, and I am the nodal officer of your institute. So please do not hesitate to come to us. We try to giving you the best idea how to file and what other things can be done easily. Okay, so thank you. Thank you very much.
Thank you so much for sharing your knowledge and experience with us. We are all glad to have you here.
I would like to request Professor Ajanta Palit ma'am to present the certificate of appreciation. And also, sir,
ভিডিও কেটে দিস ভিডিও কেটে দিস কিচ্ছু পারবো যা ভাবছো দেখো ম্যামের কাছে তুই আর দিবি কি
Now I would like to call Professor Tuhina Chakraborty ma'am to represent gift to our speaker. Sir, I would like to call upon you stage for receiving the gift. Give a big round of applause. Now, for this wonderful session, I would like to request Professor Debolina Barit ma'am to give vote of thanks.
থ্যাংক ইউ
Hope all of you have enjoyed and gathered quite a good knowledge about IPR and IP management for startups. I feel honored and privileged to get the opportunity to propose a vote of thanks on this event. I, on behalf of Institutions Innovation Council of BIT, I convey my deep regards and hearty thanks to our honorable speaker, Dr. Jyoti Sekhar Banerjee, HOD of CAC AIML department at BIT, for his wonderful speech on this event. I would like to extend my thanks to our IIC President, Dr. Orpita Chakraborty, IIC Vice President, Dr. Tapan Kumar Pal, for this valuable presence in this event. I would like to express my special thanks to IIC Calendar Activity Coordinator, Professor Sudipto Dotto, IIC Calendar Activity Advisor, Professor Bulbul Mukherjee, and all the members of IIC Calendar Activity, Professor Kuntala Dash, Professor Dr. Shutopa Roy Mishra, Professor Shanti Sinha, Professor Rajesh Roy, Professor Subhra Sarkar, Professor Vishwajit Maiti, Professor Shreyoshi Mitro, Professor Orpita Chakraborty, Professor Piali Pradhan. I would like to thank Professor Ajanta Palit and Piyush Datta too. I would like to thank our very motivated and dedicated student volunteers of the events, Mayuri Banerjee for preparing the banner, Aditya Pratap Tejasvi and Shagnik Sen for anchoring, Tuhin Kanti Paja and Jeet Shatra for photography, Monoshish Raj Rai for videography, and Rupam Ghosh and Rahul Dash for felicitation and coordination. Last but not the least, I would like to thank all the participants of the event, including the heads and the faculties of CACIT, ECE, AIML, and BT departments for their presence in the seminar. Thank you all.